Senator McGrath.
Thank you, Madam Acting Deputy President. It gives me pleasure to speak on the Migration Amendment Protection and Other Measures Bill 2014. The Coalition went to the last election with a promise to build a safe and secure Australia. A key part of this, Madam Acting Deputy, it started already. It started talking. That is a record for Senator Cameron, Madam Acting Deputy President. That was
Senator
20
McGrath,
seconds.
We'll ignore the interjections, and Senator Cameron will abide by the standing orders of the Senate. Thank you, Senator McGrath.
Madam Acting Deputy President, I can't ignore Senator Cameron. He is the light on my hill sometimes, so the light on my hill. But I'm happy to talk about promises, Madam Acting Deputy President, because we went to the election promising to stop the boats, which we have stopped, and we went to the election promising to get rid of the carbon tax, which we got rid of the carbon tax, Madam Acting Deputy President. We promised to get rid of the mining tax. And we promised to get the budget under control, and that's what we are doing at the moment, except for the rambunctious behaviour of the Labor Party in terms of their rather quirky approach to good fiscal and economic management. But what, Madam Acting Deputy President, what I'd like to do is address most of the remarks today. As much as I'd love to have a good chat with Senator Cameron, I think we should focus on the Coalition's commitment to stop the boats. And the Coalition at the last election, and actually the 2010 election, went to the election, Madam Acting Deputy President, to stop the boats, because we wanted to build a safe and secure Australia. Now, this included a package of measures in terms of the policies that we did take to the last election, such as turning back the boats where we're safe, and the reintroduction of temporary protection visas that were previously very successful in stopping the boats during the term of the Howard government. Now, despite being opposed by Labor and Greens at every turn, this government's strong stance has had an excellent success to date in stopping the boats, preventing deaths at sea, and getting children out of detention. And because we're building a safe and secure Australia. Now, I think we've had some interjections here, but I'm very happy for you, Madam Acting Deputy President, to talk about Labor's record and the Greens' record when they are in government, because they don't want to talk about their record when they're in government, because for Labor and the Greens, for the period between 2000 and 2013, they have a collective amnesia in terms of what happened with border protection and building a safe and secure Australia. It was Labor and the Greens under the Rudd government that weakened Australia's borders and caused an influx of people smuggling and of boats arriving on Australia's shores. Now, Labor pursued 11 immigration policies while they were in government. Now, Tony Abbott and Scott Morrison and Peter Dutton have led the government's charge to build a safe and secure in Australia.
Senator,
and despite this,
can I just remind you to call the gentleman that you just mentioned?
The Prime Minister and the relevant ministers. I take your point. The most excellent Prime Minister, Tony Abbott, and his most excellent ministers have pursued fantastic policies to build a safe and secure in Australia. But sadly, despite the government's success, Labor and the Greens continue to refuse to support the only policy package that's actually getting children out of detention. Now, when Labor came to office in 2000, there were no children in detention. There were none. There was zip. There was zero, there was null, there were nil. There were no children in detention. Now, children in detention under Labor and the Greens peaked at 1,992. So in 2007, when Labor came to power, there were no children in detention. But at the peak under the Labor-Green government, there were just under 2,000 children in detention. And what I'm hearing at the moment are the interjections from Labor and through you, Madam Acting Deputy President, in terms of why they're so proud or not proud or suffering from collective amnesia as to why there are 2,000 children in detention under the Rudd-Gillard-Rudd government. Now, In August 2013, just before this coalition government came to power, there were 1,743 children in detention. Today, thanks to the policies of the coalition government and support from crossbench senators, there are no children in detention on Christmas Island and under 120 children in detention on the mainland. And I agree with the previous speaker, Senator Canavan, that none of us wish to see children in detention, which is why when the Howard government lost office in 2007, there were 0 children in detention. So I'm perplexed sometimes by Labor's approach to securing our borders, considering their failures between 2007 and 2013. Because these statistics, more than anything, actually highlight the hypocrisy of Labor and the Greens when it comes to border protection. Now, the Migration Amendment, Protection and Other Measures Bill 2014 seeks to build upon our coalition's successful border protection policies, in particular those introduced by the Migration and Maritime Powers Legislation Amendment, resolving the Asylum Legacy Caseload Act of 2014, which for the ease of people, which is called RALC, which was passed on the final sitting day of last year. Now RALC reintroduced temporary protection visas. This was about getting children out of detention on Christmas Island and introduced the fast-track system, amongst other measures. This bill, the one we're talking about today, seeks to amend the Migration Act of 1958 to increase efficiency and enhance integrity on the onshore refugee and complementary protection status determination process, and is necessary for RALC to work efficiently. This bill clarifies the responsibilities of asylum seekers to provide and substantiate claims in relation to protection visas, so that if they do not cooperate with the government to establish their identity, they will not be given the benefit of a protection visa. This strong stance is in line with the law in other comparable nations, such as the United States, the United Kingdom and New Zealand. The bill will enable the Refugee Review Tribunal to draw an unfavourable inference about the credibility of claims or evidence that are raised by a protection visa applicant for the first time at the review stage. Currently, non-genuine asylum seekers can game or can play the system by presenting new claims or evidence to bolster their original unsuccessful claims, causing significant processing delays for other genuine applicants. Under this change, the incentive will be for all applicants to present all of their documentation and evidence at the first instance, rather than seeking to have multiple bites of the cherry. Secondly, the bill will also create grounds to refuse a protection visa application where an applicant refuses or fails to establish their identity, nationality or citizenship. Establishing an applicant's identity is vital for making a decision to grant or refuse a visa. An individual's identity, nationality or citizenship can have a direct bearing on whether they engage Australia's protection obligations. These measures make it clear that Australia expects protection visa applications to be made in good faith, and presenting bogus documents for the purpose of establishing identity will result in refusal of a protection visa application unless the applicant has a reasonable explanation. The bill also restores the more likely than not threshold for complementary protection. This was originally Labor Party policy when they introduced the complementary protection provisions back in March 2012. But yet, in another display of hypocrisy on border protection, because of their collective amnesia for the period between 2007 and 2013, Labor are now opposed to the measure, one which they actually argued for in the full federal court when they were in government. The government is not, this government, the coalition government, is not seeking to raise the threshold, but merely returning it to the level which was set by Labor. To be clear, though, the bill makes no change to the threshold applied to the Refugees Convention. And the fast-track process established by the RALC cannot operate fully unless a number of technical amendments in the bill are passed. Without the bill passing, the majority of illegal maritime arrival, the majority of the illegal maritime arrival backlog, which is approximately 22,000, living in the community on a bridging visa, do not fit the definition of a fast-track applicant and cannot be processed as such. And in all of this, the government is committed to ensuring Australia's compliance with its international obligations under the Refugees Convention, the International Covenant on Civil and Political Rights, and the Convention Against Torture. The statement of compatibility with human rights which accompanies the bill addresses relevant human rights issues for each measure. And I propose, Madam Acting Deputy Chair, to just look into detail into a couple of the measures that are in the bill. And it's a reminder that this bill is intended to improve the integrity and consistency of decision-making in and prevent exploitation of the protection visa determination process, including the merits review system by applicants not genuinely pursuing a protection claim. The amendments in this bill send a clear message that asylum seekers have certain responsibilities. For instance, they are responsible for establishing their identity, nationality or citizenship wherever it is possible to do so. They are also responsible for making comprehensive claims to protection supported by evidence as soon as possible. The measures will apply to all asylum seekers regardless of their mode of arrival. These amendments are necessary to ensure continued public confidence in Australia's capacity to assess claims for asylum and to support the Australian community's expectations that asylum claims are made in good faith. They are an effective response to the evolving challenges in the asylum seeker caseload, recent judicial decisions and the management of the backlog of illegal maritime arrivals. And it must be stressed that the bill is consistent with Australia's international obligations under the Refugees Convention, the International Covenant on Civil and Political Rights and the Convention Against Torture. Decision-makers, in terms of procedural fairness, must act in good faith to fully assess protection visa applications and afford procedural fairness to asylum seekers in accordance with the codes of procedure in the Migration Act. Decision-makers are also provided with guidance to be aware of the special needs of vulnerable applicants and to ensure appropriate support and consideration is provided. For instance, the Department's Procedures Advice Manual, Gender Guidelines and Refugee Law Guidelines assist in assessing claims from vulnerable applicants, including women and applicants with an intellectual disability. Vulnerable applicants include unaccompanied minors, survivors of torture or trauma, and applicants who are physically or mentally incapable of taking full responsibility for their claims. Now, one of the sections I really wanted to talk about was Section 5AAA. Now, the purpose of this provision is to strengthen the integrity of Australia's processes for assessing protection claims. Early and full presentation of claims allows refugees to be recognised at the earliest opportunity. The proposed Section 5AAA clarifies and clearly communicates responsibilities with regard to protection claims and supporting evidence by stating existing responsibilities on the face of the legislation. Now, this particular provision is necessary because it puts a basic responsibility of an asylum seeker beyond doubt by stating it on the face of the legislation. The proposed Section 5AAA expressly places the responsibility on the asylum seeker to make their case for protection. It clarifies that a claim that a person engaged in protection needs to be comprehensive and supported to the best of the asylum seeker's ability. This is an existing basic expectation of the Australian community and the government, as well as a long-standing general principle of refugee status determination that the burden of proof lies with the asylum seeker. The new Section 5AAA codifies the obligations of an asylum seeker within the Migration Act, consistent with the way in which obligations of a decision-maker are actually codified. Now, I need to stress that under 5AAA, it states the responsibility of a person seeking protection in Australia needs to specify all the particulars of their claim and to provide sufficient evidence to establish the claim. Now, I want to read out that this responsibility is consistent with an acknowledged, long-standing principle of refugee status determination and out of the UNHCR handbook, to quote, is a general legal principle that the burden of proof lies on the person submitting a claim, at paragraph 196. Now, there are also responsibilities of the decision-maker under Section 5AAA. Section 5AAA clarifies that the minister or their delegate has no responsibility or obligation to assist in making a claim on behalf of an asylum seeker or to assist in establishing that claim. It clarifies that it is not the role of the decision-maker to advocate on behalf of a person seeking protection. The role of the decision-maker is to decide whether there is an obligation to provide protection by appropriately investigating and evaluating a claim for protection. The duty to evaluate and ascertain all relevant facts is shared between the applicant and the decision-maker, consistent with UNHCR guidelines. The decision-maker should ensure the applicant presents the case fully as possible and with all available evidence to assess the applicant's credibility and evaluate the evidence in order to establish the facts of a case consistent with the UNHCR handbook, which is at paragraph 205. Decision-makers may continue to ask questions, seek clarification and check that a person's claims are consistent with generally known facts and the specific country situation in question. Procedural fairness requirements of decision-makers are codified in the Act and will continue to apply. Decision-makers must act in good faith to fully assess protection visa applications and afford procedural fairness to asylum seekers in accordance with the Codes of Procedure in the Migration Act. Any available evidence that supports the specific protection claims made by the applicant are to be presented. There is no, under the 5AAA, there is no prescribed list. Detailed, up-to-date country information will be available to decision-makers, and the minister or their delegate needs to be satisfied that the visa criteria are met based on their assessment of the claims and evidence provided by the applicant. Consistent with page 40, paragraph 205 of the UNHCR handbook, the applicant is to supply all relevant information in as much detail as necessary for relevant facts to be established. The applicant should make an effort to support their statements by any available evidence and give a satisfactory explanation for any lack of evidence. If evidence be missing, they must make an effort to procure additional evidence. I also, with the time that is available to me, Madam Acting Deputy President, I touch upon sections 91W and 91WA. Now, the purpose of these provisions is to encourage people seeking protection in Australia to provide documentary evidence of identity, nationality or citizenship wherever possible. While both measures include a refusal power, their primary purpose is not visa refusal, but compliance with the objective of establishing their identity, nationality or citizenship of the refugee with genuine documents. Now, these provisions are necessary because sections 91W and 91WA are needed to discourage the use of bogus identity documents and the destruction or discarding of documentary evidence of identity, nationality or citizenship by or on behalf of people seeking protection in Australia. These measures are appropriate to the central role that establishing identity, nationality or citizenship plays in granting a protection visa. Establishing identity allows accurate assessment of a person's protection claims, particularly in a time of increased dual and multiple nationalities. These measures also help safeguard the Australian community from people who have committed serious crimes. Now, under the existing Section 91W, a decision-maker may request that an applicant provide documentary evidence of identity, nationality or citizenship. At the time the request is made, the applicant is warned that the decision may make an inference. And Madam Acting Deputy President, we've missed Senator Cameron. Senator Cameron, I think, must have been reading some very interesting emails there, because we didn't have Senator Cameron. We didn't, for you, Madam Acting Deputy President. The Labor benches were quiet when we were talking about children in detention, Senator Cameron. So why don't we have some pithy and witty interjections from the Labor Party in terms of where were you, what were you saying when when children were in detention under Labor? Where were you when just under 2,000 children were in detention? Where was Senator Cameron and the Labor Party? Where were they? Oh, you know what? They were in power. They were in government. The Labor Party was in power and they were in government when 2,000 children were in detention. And now we have the collective amnesia of the Labor Party who have this appalling, sanctimonious approach to the 120 children who we have in detention, and the number is going down. So this bill should be supported.
Thank you, Senator McGrath. Your time has expired.